Let us discuss the next question. This is from the year 2023. In essence, what does due process of law mean? A. The principle of natural justice. B. The procedure established by law. C. Fair application of law. D. Equality before law. Now we have to see what does the due process of law mean out of the given statements. Now what does due process of law mean? Due process of law means it involves two things. One is the substantive due process and the second, the procedural aspect. When we say the procedural due process, we just check if we have followed the procedure or not. That is the procedure established by law. Whatever is the law, whether we have followed the law or not, whatever is the procedure mentioned in the law, whether we have followed it or not, we are not concerned with the fairness of the law. We don't question if the law is just or not. We are purely concerned with the procedure and what is written in the law. That is procedure established by law. When we say substantive due process, we check the fairness of the law. We checked whether the law is just or unjust law. So that is the fair application of law. Checking the law for the fairness, checking the law for being just or unjust. When we say fair application of law, it means that whoever the person is, irrespective of discrimination, without doing any discrimination, you have to fairly apply the law. And when we say equality before the law, it means that whoever you are, in the eyes of the law, you are the same. Whether you are rich, poor, high caste, low caste, doesn't matter. In the eyes of the law, you are equal. Be you ever so high, you are equal in front of the eyes of the law. It doesn't matter. So that is equality before the law. But when we say principles of natural justice, it involves both substantive due process and the procedural due process. Here, if you can see the option B only involves one aspect, that is the procedural due process. If you look at fair application, it is just concerned about whether the fair application is happening or not without any discrimination. So it is slightly concerned with the fairness and whether the law is just or not. It is also concerned with only one aspect. But when we say due process of law, it has to have the substantive due process and also the procedural due process. And the option that will sync with this is principles of natural justice. What are principles of natural justice? Just because you are a human being, you have certain rights which you have to get. Those are natural rights. Similarly, the principles of natural justice say that not only you have to check the procedural due process of a law, not only you have to check the procedures, but at the same time, the law should not be arbitrary. The law should be fair. The law should be just. And all this concept is related to the due process. Out of the principles of natural justice, the implication and what comes out of the principles of natural justice is the due process of law. So the correct answer here is A, the principles of natural justice. Now let us look at the in-depth explanation. Due process of law. It ensures that the laws are not simply followed. The simply following the laws is the procedure established by law. So due process is not just the laws are simply followed, but we also check whether the laws themselves are fair, are they just, are they reasonable enough. So this will be considered. When we say due process, like I already explained, it involves both substantive due process and the procedural due process. This concept originates from the United States Constitution. And because this process will look at both the substantive aspect and the procedural aspect, we can say that it involves the principles of natural justice such as fairness, reasonableness, and law being not arbitrary, and all of this. Procedural established by law. Here we are simply adhering to the laws and procedures laid down by the laws. We don't check whether a law is just or fair, whether the law is arbitrary or not, whether the law is just or unjust. When we say fair application of law, it means that the law has to be applied impartially without any discrimination or bias so that justice is spread to everyone. Here the more importance is given to the fair application, that is the fair implementation of the law. But again, here the problem is we are saying the law has to be fairly applied to everyone. At the same time, we are only focusing on the implementation of the law and we are not discriminating anyone while implementing the law. But are we checking the genuinity of the law itself? Are we checking the reasonableness of the law itself? Are we checking whether the law itself is fair or not? We are not doing that. So this covers only the substantive aspect, and also it is not concerned with the procedural fairness. So this is also not a holistic coverage. And again, when we say equality before the law, it means that there are no special privileges for any person and all people are equal in front of the ordinary law of the land and no person is above the law. Now coming back to the question, the procedure established by law covered only one aspect, the fair application covered only the fairness aspect, and equality before law is concerned about the equal application of the law and not treating anyone as special. But what actually covers the principles of natural justice? What covers the justice, fairness, reasonableness of the law and also the procedures? The principles of natural justice will lead to the culmination of the concept of due process of law, which involves both the substantive aspect and the procedural aspect. So A is more right and relevant answer because it is more holistic and is more in sync with the due process. Whereas B and C, they only cover one particular aspect of the concept. So A, the principles of natural justice, is the correct answer.